Senator Beavers, you're recognized on the resolution.
Thank you, Mr. Speaker. I would move SJR 63 on third and final consideration.
Senator Beavers renews her motion for passage SJR 63 on third and final consideration. That is seconded. Senator Beavers, you're recognized on resolution 63.
Thank you, Mr. Speaker. SJR 63 will allow the citizens of Tennessee to decide whether they would like to elect their Attorney General or if we should keep the current system whereby the Supreme Court appoints the state's chief lawyer who routinely appears in front of them. This amendment would provide that the Attorney General would serve for 6 years beginning in 2020, and he or she could only serve 2 consecutive terms. This is more important than previous years. Many of you know that I've brought this bill during the previous few General Assemblies. You've heard my many arguments that on its face, our current system appears to be unfair. An attorney arguing before the very body who appointed him. Think about that. What if defense attorneys had to try a case against district attorneys who were appointed by the same trial judge that they were appearing before? On its face, there appears to be a conflict of interest. However, I also believe that this amendment is needed more than ever. In last year's election, the citizens decided that they wanted their Supreme Court justices to be appointed by the governor. When the current system was envisioned by our founding fathers, the Attorney General was to be appointed by an elected Supreme Court. Yet after the Tennessee plan and the vote of the people on Amendment 2, the AG is now twice removed from those he or she is supposed to represent, the people of Tennessee. Currently, Tennessee is the only state in the nation where the people, either through their directly elected representatives or through their own popular vote, have no say in selecting the people's lawyer. The AG is supposed to be accountable to all 3 branches of government, a unique position that is different than any other elected official or constitutional officer. If we allow the legislature to select the AG, you would end up with the same problem that we have now. On its face, the AG would seem to be beholden to one branch of government and its leaders. The AG should be accountable to all branches and all people. I'm not trying to disparage our current Attorney General, who I believe to be a fine lawyer. However, let's not fool ourselves. Our AG was chosen by some judges who he himself interviewed and helped put on the bench. So don't tell me that there are no politics in the current system. I keep hearing people argue that if we have an elected Attorney General, he or she would not follow the Constitution and would be more beholden to political pressures. To that argument, I ask each and every lawyer in this room, do you refuse to uphold your oath as a lawyer and a senator simply because you're an elected official? Do you refuse to uphold your oath to follow the Constitution because you have to raise campaign funds? This argument should be an insult to every lawyer in this room, that somehow an elected Attorney General's ethics would be compromised if he or she were to have to run for election. There are some great lawyers in this room who have continued to be great lawyers despite having to campaign and be elected by their constituents. I would hope that you would have the same level of respect for the citizens of the rest of this great state as you apparently have for your own constituents, that they would be able to elect a great Attorney General to uphold and defend our Constitution and help represent all 3 branches of government. One final point to the people who say that the Attorney General throughout the rest of the country often use that job to propel themselves to governor. To that I say, so what? Why not have a qualified and competent legal mind running for the top office in our state? Our state is tied for dead last in the number of statewide elected officials. We have only 3 people who are elected statewide. Think about that. California has more trust in their citizens to elect their state officials than we do. That is unacceptable. I welcome more statewide elected officials. It's time to let the citizens have more of a say in their state government. And with that, Mr. Speaker, if there are questions, I would answer them this time.
Thank you, Mr. Speaker and colleagues in the Senate. Many of you have heard the arguments, pros and cons, many times on the proposal before you as reflected in SJR 63. It puts me in mind of the 1993 movie Groundhog Day starring Bill Murray, where Bill Murray's character was in a time loop, repeating the same thing day after day after day. This issue has been before the Attorney General, before the General Assembly as far back as I can remember, and it's never advanced to the ballot, and for good reason. That's why it seems to me we're in a time loop, repeating the same thing year after year after year. I think this body understands the simple fact of the matter is that the way the state of Tennessee has selected its Attorney General has worked and continues to work since the adoption of the 1870 Constitution. I would respectfully submit that we should only change what has been in place when it no longer works. No one has come forward to show that the way we do it, and have done it since the adoption of the 1870 Constitution, has not served us well. The current system has produced a long line of distinguished Tennessee attorneys general, and it's an office that is respected as independent, professional, and nonpartisan. Those serving in the Attorney General's office are there because they want to be Attorney General, not to further a public or political agenda. You've heard the argument made about attorneys practicing before judges who appointed them. That happens every day in this state, and no one has said that that doesn't work. Judges every day appoint guardians ad litem, they appoint conservators, they appoint indigent defense counsel. And all of those lawyers are practicing before the judge who appoints them. And no one says that there is an ethical problem or any other problem associated with that, or that the lawyers don't do a good job. The executive branch and this legislature rely a great deal on opinions from the Attorney General. Under the current system, it is clear that the advice and formal opinions from the Attorney General's office is objective and honest, whether or not we always like it or agree with it. Legislators would be reluctant, I submit to you, and understandably so, to make requests and share sensitive information where the Attorney General has a political agenda. This would be true of the executive branch as well. The value of the Attorney General's advice will diminish, leading to uninformed decisions resulting in costly litigation for the state. I would urge you today that we should respect the sound judgment of the drafters of our state's Constitution, honor our traditions, and keep with Tennessee's unique and proven system of selecting the Attorney General. The current system was established in 1870 and has been free from scandal, fraud, and abuse. Simply put, there is no compelling reason to change, and I would submit that we should not support SJR 63. Thank you, Mr. Speaker and colleagues in the Senate.
Thank you, Mr. Speaker. What my young friend from Blount County failed to say was 1870 Constitution provided for the Supreme Court justices to be elected, and then those elected judges appointed the Attorney General. Since then, we have changed the system recently into where the Supreme Court justices are appointed. So now we're in the unique position to have appointed judges appointing the Attorney General. We don't want appointees being appointed by appointees. We're going to have to change it. We're either going to have to let this body select the Attorney General the way we do our constitutional officers, or we're going to have to let the people statewide elect them. Either way is fine with me. They'll both work better than what we've got, one or the other. My opinion is pass this one, think about it a year or two, and then settle on one. But to let appointed judges appoint a Attorney General, in my opinion, will not work very long. Thank you.
Thank you, Mr. Speaker. I rise in support of SJR 63 because the arguments for and against it are very compelling. But what can't be denied is that the people should have their right to vote. That's what Senator Beavers proposes here. The vehicle is the resolution to put to the people the question whether the Constitution should be amended to elect attorneys general. And the debate begins here again today, but it will continue. Let the people decide. Thank you, Mr. Speaker.
Mr. Green.
Thank you, Mr. Speaker. As I think many in the body will recall, I had a bill last year, a resolution to allow us the opportunity to select the Attorney General, much like we do the constitutional officers. And we put that to a vote, and that was not successful. So the will of the body was pretty clear that wasn't what the body wanted to do. Taking that into consideration, what's the next best alternative? And I think the next best alternative is this resolution. So I rise in support of this resolution, and we'll be voting for it. I think I agree with what's been said already. The will of the people needs to be heard. And as Senator Nicely said, if there's elected people making the decision, then it's not removed from the people as it is now where appointees are appointing appointees. I agree with that. That's twice removed from the will of the people, and that's just not appropriate. So I say we give the people the vote and let their voice be heard.
Further discussion of Senate Joint Resolution 63. Senator Overby, you're recognized.
Thank you, Mr. Speaker. I'm not going to belabor the point, but the argument about appointed people appointing judges, you'll recall a few years ago, or was it last year, a couple of years ago, under the workers' compensation reform bill that was passed, and only a handful of us, I think, voted against that. Under that system where we took the workers' compensation claims out of the judicial system, and we made a system of judges within the Department of Labor to hear all of those claims, administrative judges to hear all those claims. All of those administrative judges are appointed by someone who is appointed by the governor to be those administrative law judges. So this body has already accepted that principle of appointed persons appointing administrative law judges in order to hear claims for workers' compensation, which I would submit to you is a very basic claim extended to all workers in this state. Thank you, Mr. Speaker.
Further on SJR 63. So objection to the question, I'll allow Senator Beavers to close. Seeing none, the question is put. Senator Beavers, you may close on SJR 63.
Thank you, Mr. Speaker. Yesterday was Thomas Jefferson's birthday, and a quote of his perfectly exemplifies the vote that we're about to take. In a letter to Archibald Stewart in 1791, Jefferson said, "I would rather be exposed to the inconveniences attending too much liberty than those attending too small a degree of it." Ladies and gentlemen, I ask you, do you want to be known as standing on the side of too small a degree of liberty? Or do you want to stand on the side of freedom and liberty and on the side of standing up for the rights of Tennesseans to vote and to vote for their leaders? I hope you'll stand with me and send a message to our fellow Tennesseans that we have faith in them to elect their lawyer.
Question has been put. Senator Beavers are closed. We're on the board. Those in favor vote aye when the bell rings. Those opposed will vote no. So every member voted. Mr. Clerk, take the vote.
Ayes 23, none nays.
Pursuant to Senate Rule 21 and Article 11, Section 3 of the Constitution of Tennessee, SJR 63 has been read for the third time and adopted by a majority of all the members elected to the Senate of 108th General Assembly. Without objection, motion to reconsider goes to the table.